Good morning. Today we will see one income tax judgment, section 153C, which is on search and seizure. What is section 1? What section 153C says? That we will see little later. In this case, facts are very important. First, we will see the facts. 2012-13 is the assessment year. 11/9/2012 X filed is a return of income. 4/9/2013 a search took place in somebody else's place. Let us assume that it is Y. In Y's place, 4/9/2013 a search took place. Then 1/6/2015 section 153C was amended. This is a very important date. 1/6/2015 section 153C was amended. What is the amendment? That also we will see a little later. Then 25/4/2017 the satisfaction of the AO was recorded. 4/5/2018 notice was issued. Then order was passed. Now, the issue before the Supreme Court was whether the amendment made in section in 2015 for section 153C will that be applicable to searches conducted before 2015, that is prior to 1/6/2015. Section 153C, if you take it a bigger section, let us not get into too many details. Simply put, X is the person who filed this return of income. Y is another person, his place was searched. In Y's place, if income tax department finds any gold, jewelry, bullion, or other books of accounts or documents, then that assessing officer will see all those things. They will find, okay, these things belong to X. So what they will do is, they will record that and send it to the assessing officer of X. X assessing officer will see that and then he will issue a notice that these things were found in a Y's place. You answer my question. So show cause notice will be issued, then order will be passed. Now, in this case, the search was conducted at the other place on 4/9/2013. At that time, what 153C said was, if the gold bullion or the other documents and these things, if it belong to, that was the word, which is the crucial word in that section. Then the assessing officer of X can assess the X income based on that. After 2013, in 2015 an amendment came because this belong to or belongs to was narrowly interpreted by the Delhi High Court. In some case, in the Pepsi case, Delhi High Court said it says belong to or belongs to, then this will not apply to this person. So they have made some judgment on that. To overcome that judgment, the act was amended by substituting the words in place of belong to or belongs to, pertain or pertains to. These words were added. So now X said the search was conducted in 2013. So I have a substantive right that if they apply that section standing on 2000 prior to 2015, then that income, that whatever it is searched, that cannot be included in my income. This was the contention of X before the Supreme Court. So what was found in Y place was there was a hard disk in the Y's place. When income tax authorities searched, they found a hard disk. In that disk, X name was mentioned in an Excel sheet. Based on that, the report was sent. So now the X challenged the assessment order before the Supreme Court. Supreme Court said proviso, there is a proviso in section 153C, which is very, very important. It says the date of indication of search is deemed to be reference when the AO of the non-searched person, that is X, receives books of accounts or other documents. So, what is the date of search? In such a case, for the non-searched person, in this case X, it will be the date on which he receives the books of accounts and other documents. This is what the proviso says. It is a deeming fiction. So, Supreme Court applied this deeming proviso to this person, X1. So, in that case, Supreme Court said that since the books of accounts were received by the assessing officer of X on 25/4/2017, that is subsequent to the amendment, the new section, the amended section 153C will be applicable. Second is, this is also one of the interesting points. Supreme Court said the amendment is by way of substitution of words. We said 153 say earlier, prior to amendment contained belong or belongs to. Now they have amended it pertain or pertains to. Supreme Court says when the words are substituted in the place of the other words, then it has the effect of wiping the earlier provision from the statute and replacing it with the new provision. So, completely that belong or belongs to will go away. Then this new pertain or pertains to will take place. It has the effect of wiping out the earlier provision. This is what Supreme Court said. Thirdly, Supreme Court said 153C is a machinery provision. This has not been disputed. When a machinery provision is in the taxing statute, then it should be construed to it should be interpreted in such a manner to give effect to the object and purpose of the act. The object and purpose is if somebody is suppose X is gold or bullion jewelry is found in some other place, then X has to be assessed. His income has to be reassessed because that will escape the assessment. So the object and purpose is to bring that into his income and then assess it. That will get defeated if it is not given effect. That being a machinery provision, it should be given effect, is the Supreme Court's view. The other thing is the contention of the respondent. The respondent in the sense X in this case. He said, I have a substantive right and hence this should not be, the amendment should not be applied retrospectively, was completely rejected by the Supreme Court. So, Supreme Court held that the amendment brought in to section 153 in 2015, it will be applicable even for searches conducted prior to 2015. This is the sum and substance of the judgment. I thought this is an interesting judgment which I wanted to share with you. Thank you very much. Have a great day.